As you can tell, the ACLU is extremely concerned that the city's actions are undermining rather than strengthening the CRB's ability to provide Baltimore residents with transparency and accountability that the residents clearly want, and which has been stressed as a key change by the Department of Justice and the Civilian Oversight Task Force, as well as the advocacy community. We must be vigilant, this body, the voting members especially, must be vigilant in protecting against the law department's impulse to protect the police and the city from the consequences of police abuse. First, the city solicitor's office is defying settled state case law by claiming that the Civilian Review Board's ability to obtain records is determined by the Public Records Law, or MPIA, the Maryland Public Information Act, instead of its statutory authority. This would mean that the CRB cannot access police records any more than anybody else in this room, which means that we can't get most records. The statute that created the CRB gives us subpoena power and access to records because we need more access than the general public to do our job. What's worse is the law department is attempting to severely limit our ability to communicate with the public, including the individuals who file complaints with the CRB. These changes have almost entirely erased the small amount of transparency that we're currently permitted to use. So the board members are getting even less information, and then we're being told that we can give even less information to the public. Some of the specific things that I have read in the notes of the meetings that you guys have had with the law department is that the CRB is not allowed to speak directly to the DOJ, that agendas must be approved by the city solicitor's office before we release them, that findings letters cannot be sent to the complainant, even if they're redacted, that body-worn camera footage will be redacted and provided to the CRB, which is what I get at the ACLU all of the time. You guys get no more than anybody else. And that subpoenas for the IAD casebooks will be considered under the MPIA. We have subpoena power because we don't have to go through the MPIA. So this clearly is unacceptable. These changes are going in the exact opposite direction, that at a time when everyone except the police department wants us to be moving for more oversight. This is going in the wrong direction, and we should have learned a lot from the deaths of Freddie Gray, Tyrone West, the Gun Trace Task Force, the death of Detective Suter, all of these cases that we have discussed, the victims who have come here and spoke to us. And the city government should be empowering the CRB to help us, not restricting and silence us. So what I want us to do, maybe not today, is talk about what formal requests we might be able to make publicly and to the city. I strongly suggest that we ask for independent counsel, and we also ask that our elected officials take swift action to protect the CRB and the public's right to know what the police and the CRB are doing.